So on Monday this week, we saw closing arguments being handed in for the landmark case of Apple and Epic Games, who is the creator of the popular game Fortnite. The final verdict is not due to be delivered for a few more weeks, but the trial itself was significant in many ways. It revealed much of Apple's inner workings, and saw its CEO, Tim Cook, taking a witness stand for the first time ever. His testimony was particularly significant, as he would have to answer questions about Apple's business practices while under oath. So in today's video, we will be looking at the legal challenge issued by Epic, what happened in the actual trial, and what would be the implications of a verdict going either way. So what is the legal challenge that Epic has brought against Apple? Epic has challenged Apple's practice of taking an exorbitant 30% commission on all in-app purchases, infamously known as the Apple tax among iOS app developers. In its lawsuit, Epic also criticized Apple's policy, which prevents any attempts by app developers to bypass this 30% commission, such as by offering their own direct payment options to consumers. Moreover, it criticized the App Store's paid promotion feature, which allows companies to pay to appear as the top hit in searches. So, even if you type Fortnite in the App Store search, it may not be the first search result that you see. Essentially, Epic has accused Apple of holding a monopoly with all these practices. It has said that with Apple's unlawful conditions and policies, Apple ensures that the App Store is the only distribution channel for developers to reach iOS app users, giving Apple overwhelming monopoly power in the iOS app distribution market. Apple has argued that its 30% cut is justified, as it reflects the immense value of the App Store, and it also charges app developers for useful background features. Apple has also argued that its policies are essential to keep iOS apps within the App Store, to secure its high standards for privacy, security, content, and quality. Now that we're all up to speed with the challenge, we can move to the trial. In the trial, there was a lengthy argument over the legal definition of the term game, and whether Fortnite was in fact a game. Epic's counsel argued that Fortnite was more than a game. It was a metaverse, a virtual world where participants can socially interact. By doing this, Epic's counsel was attempting to broaden the scope of the lawsuit out to all the apps in the App Store, while Apple was attempting to limit it to only gaming apps. Judge Gonzalez-Rogers said that there was no legal definition of what is a game, and we will have to wait until the verdict is delivered to hear her deliberations on the matter. The App Store's profit margins were also discussed in the trial. Epic claimed that the App Store operates on a massive 78% profit margin, which reflected its monopolistic power over developers who are forced to go through the store to reach Apple's 1 billion iPhone users. Apple disagreed with this figure, but significantly, they did not rebut with a figure of their own. They said that they could not calculate a margin figure due to the way they calculated costs and revenues for the App Store. Epic's counsel stated that Apple's reluctance to provide its own figure was evidence that Apple was aware of its own anti-competitive behavior. Tim Cook's testimony was perhaps the biggest turnaround for Epic's case, as it dealt a serious blow to Apple's credibility. Apple's CEO tried to sidestep the question about the App Store's profit margins, and demonstrated ignorance of Apple's inner operations when faced with detailed questions during cross-examination. It is hard to believe that the chief executive was unaware of at least profits of their own company, so claiming ignorance was viewed as a way to avoid giving incriminating answers. Judge Gonzalez-Rogers was also not satisfied with Cook's response on her question on why Apple dropped its 30% commission to just 15% for certain purchases last year, just after Epic filed its lawsuit. She doubted that the drop was as a result of competition, and rather appeared to be as a reaction to litigation. Market definitions were also discussed in the trial, as defining the parameters of the relevant market is likely to be crucial in determining whether Apple operates a monopoly or not. In this part of the trial, Apple appeared to have the upper hand, as Epic would have the difficult task of convincing the judge that Apple devices were a singular market in themselves. Cook noted that consumers always have a choice to switch to another smartphone, and app developers could always follow them. Apple also argued that the market was even wider for Epic's top-selling game Fortnite, as players could still find it on Xbox, PlayStation, and PC. It pointed out that App Store purchases accounted for just 7% of Fortnite's revenues, indicating that the market that Epic was operating in was much larger. Throughout the trial, Epic argued that there was no reason why iPhones could not operate more like MacBooks, which allow their users to download apps from the web rather than the Mac Store. Apple's response was surprising. It said that the Mac had security risks that iPhones did not. This meant that allowing iPhones to operate in the same way as MacBooks would threaten the entire app ecosystem, and giving up control over apps would result in the iPhone turning into a toxic mess. Both sides presented strong arguments for their case, so there were no indications that the judge was leaning strongly either way. On the one hand, she seemed reluctant to take actions that would radically transform Apple's business model, asking Epic's counsel whether they could find her a single precedent which supported the type of relief they were asking for. She said it is a pretty significant step that the courts haven't done. She also noted that Epic's challenge was attacking the fundamental way that Apple was generating revenue, adding that there's a reasonable argument that Apple is using these profits to benefit the whole ecosystem. On the other hand, Judge Gonzalez-Rogers was also concerned of Apple's 30% commission, noting that the rate had been there since the beginning of the App Store. She said if there was real competition, that number would move, and it hasn't. So what would be the implications of a verdict for either side? If the case was decided against Apple, the most significant impact would be that they would have to make sweeping changes to their App Store's business model, such as forcing them to open the iPhone to rival app stores. A negative verdict would likely affect other antitrust probes happening elsewhere in the globe. For example, in the EU, Apple has been charged with antitrust abuse by Spotify over similar complaints of its high commission fees and restrictions on developers. A negative verdict for Apple could also be a red flag for other big operators, such as Google, whose Play Store has a dominant position on Android handsets. On the other hand, if the case was decided against Epic, it would result in a reinforcement of the status quo, and it would set a dangerous precedent for app developers that seek to challenge the Apple tax in the future. However, even if Apple wins, has it really? The legal challenge has exposed Apple's business practices for the world to see, and the trial has also damaged its credibility. Thank you for watching this video. Don't forget to leave us a like, comment, and subscribe for more great content.